Oh, hi. Good evening, everybody. Thanks for joining tonight's public sort of legal discussion panel just between David and me. Um, First, a little bit of sort of housekeeping items. First off, this is um, sort of a free, um, essentially fireside chat between David and me. And we are not giving any legal, tax, or investment advice to anybody. And if you need any kind of legal advice, whether from me or David, you need to reach out to us. And before we form any kind of formal attorney-client relationship with you, we don't have such attorney-client relationship with you. And to the extent you decide to share anything with us or ask any questions, to the extent we give you any kind of initial feedback, that does not constitute any legal advice either. And for the record, right now, there are nobody who essentially object to me recording this meeting. For anybody who is not speaking, can you please mute your phone, mute whatever devices, microphone that you are using? So without any further ado, let me just uh, have David. I'm sure most of you know me directly or indirectly already, so I do not need much introduction about myself. I'm going to just have David explain himself, introduce himself, and explain to you, his background and how what's the topic that we're going to cover tonight. Thank you, David, and thanks to everybody for attending this. And David, the floor is yours now.
Thank you very much. Thank you so much, everyone, for taking time out of your busy lives to come chat with me. My name is David Bustamante. I'm an estate planning attorney. I've been practicing estate planning since about 2018, 2019. And I work with law firm, Rosenblum Law Firm, as well as law of Ciro Spina to help protect families against the unforeseen. I help protect families through creating trust to protect their real property, to protect business interests, and also safeguarding children, safeguarding the next generation to come in an efficient and seamless manner, as well as working with a variety of clients on a number of either business or real estate issues that may arise. But that's for me. And again, thank you so much to everyone. I know this topic's really important, so I'm glad to see everyone here. I believe you're still muted, Lou.
Oh, hi, David. So I do corporate work. A lot of clients, before they get into legal trouble, they will not do what we corporate lawyers think are bare necessities. For example, they may have partner, at in their venture, but they never have fully documented, respective allocation of responsibilities and obligations and all that. But so, what kind of misperception people usually have relative to the work you do, and when what's sort of the common misperception and misunderstanding that people have when they hear the term estate planning?
Phenomenal question. And really, the misconceptions that I come across are people think that because you have an estate plan, because you have something called a trust, that you are losing control of your assets, that you are saying that this is no longer pertaining to you. You have no say over it. Again, it's a loss of control many people believe that they face. It's
Hmm.
actually quite the opposite. With a trust that's structured for your needs, it's about maintaining control, ensuring that it's there for the next generation, there for your business partners, there for your family during those times. On top of that, frankly, one of the other misconceptions I often hear is that estate planning is really just about who gets what, when, and where. And honestly, that is a part of it. But mainly what estate planning is about is family, peace of
Hmm.
mind, efficiency. Because honestly, and you can correct me if I'm wrong, but in life, there's the easy way and there's the hard way, right? The easy way is when there's no legal issue right now. The easy
Hmm.
way is when we have the benefit being alive, well, full capacity to make decisions for ourselves and
Hmm.
for our loved ones. The hard way is when we lose that capacity, because if someone loses capacity, they can no longer make decisions on their behalf. They can no longer sign legal documents. So the misconceptions really circle around a loss of control, but estate planning is geared towards giving that control right back to you, giving that control to your family, protecting the assets you want to protect.
I see, David. During law school, I never took any class in trust and estate. So, would it be accurate or suffice it to say that estate planning is about trying to take care of sort of your assets and decide how you sort of will allow it to be allocated and distributed and disposed of after you are gone, but when you have the legal and mental capacity to do that, would that be an accurate summary of what your work is about?
Absolutely, 110%. It's about
Okay.
making sure that all the assets are handled in the most tax efficient manner.
Hmm.
There is no sort of infighting because think about it, right? Estate planning, we're really talking about a time when we're no longer present. We're talking about that for the first time in our lives, our
Hmm.
families are having to figure out what's going to happen to the house, what's going to happen to the business.
Yeah,
So having
I
something
see.
written, we really ensure that we cover all of our stones, nothing's left unturned, and we provide guidance during its very delicate and sensitive time.
Such that we do not leave all this to the device of frankly speaking, the law or the legal struggle. Oh, I see. Okay. So, um, who needs, estate plan? Does it only apply to the ultra wealthy, or do average professionals like you and me, or and also need this kind of a legal service?
It applies to every single person.
Hmm.
And I'll be frank, I'm not remotely wealthy in that respect. But my estate plan, letting you know about myself, is for my daughter. I'll tell you a little bit about myself. I was blessed with a daughter 3 years ago. She just turned three February 9th, so not too long ago. And the first time I held her, I made a promise that dad has to be around for 200 more years, right? But I mean, the facts of life are that I probably won't make it that far. But my estate plan is to ensure that the day that dad's no longer on this earth, I've set her up, I've set my wife up in such a way where they don't have to go to court, they don't have to face any out-of-pocket expenses, that what I built for my daughter and my wife stays with them. And that, God forbid something happens to my wife as well, we've designated guardians in place to ensure that my daughter is always protected.
I
And
see.
I also know you have young children, so I'm sure you can relate with this. But
Hmm.
you know, my daughter right now, she's obsessed with a television show called Bluey. So God forbid something happens to me in a couple of years, she's going to go to Disneyland, spend all the money, right? So I've set up my estate plan in such a way where she receives a percentage when she's 21, she
Uh-huh.
receives a percentage when she's 25, and then the balance at 30, conditioned on going to college, being educated, making sure that what she receives doesn't do her more harm than good.
I see. So it's not just about continuity and stability, sort of in our children, and for some of us, I suppose, grandchildren's sort of financial life. It's also, I suppose, partly sort of for the lack of a better word, inspired by our um, constant struggle, even after we are gone, against the tax man, I suppose.
Yes, and the two facts of life, right? Death and taxes. They're not going to forget
Mhm.
about you.
I see. So, what are the essential documents that everybody would need, that everybody should have, relative to trust and estate planning? Ranging from the ultra wealthy, maybe some of them is in audience today, or the moderate wealthy, some successful business people. So, what kind of documents should be in, or integral part of their plan?
course, really, it comes down to about five estate planning tools that we use every day for our clients. The
Mm-hmm.
first of which is going to be an instrument called the revocable trust. Now, the revocable trust is an estate planning tool that grows it with your family. It's essentially
Okay.
another legal entity that we develop that houses your assets, such as businesses, real property, bank accounts. It houses these interests in trust so that way it does not have to go through a process called probate, which I can explain in a little bit.
Mm-hmm.
But the revocable trust really keeps the power with you. It ensures that you still have control over everything. If you want to sell the house tomorrow, all the power to you. You don't have to ask permission of anyone. It stays there for your loved ones without having them pay anything out of pocket. And on top of that, the revocable trust, again, it is a structure that's set up in such a way that you can really personalize it to your family's needs, whether you have young children, whether you have people that you love, but if your children get divorced, you may not want to leave them anything. You include certain protections in the trust that ensures that your wishes are followed. That's the first one.
Okay.
And our second instrument is something called a pour over well. A pour over well essentially is going to help us as our estate grows because I'm looking to be here for another 200 years. Ideally, I get more assets, we build up more things for my family. But with that, a pour over will says any future assets I receive that I come to that I have, it's my instructions, my intentions, my wishes for those future assets to pour back into my trust for the benefit of my daughter, for the benefit of my wife. So it's a little forward thinking. It's something that grows with you.
Uh,
And
so
Mhm.
essentially, the day you draft this document and execute it, um, and thereafter, if you acquire more assets, they are going to be prospectively covered by this instrument. And that instrument manifests sort of your wishes, your plan, your desire in terms of how those assets should be allocated and distributed after you're gone.
1,000% correct. And
Okay.
the best way I like to explain to my clients is that it helps you see my face less, unless you want to. But it's something we use to help people have the trust and grow with them over time.
Okay.
And
And
then, Mhm.
go ahead.
Yeah, and then really the last three instruments come down to just what happens when things go wrong in
Mm-hmm.
life. Because the facts of life are such that we're more likely now to face a type of incapacity before we ultimately pass away.
Mm-hmm.
So the last three documents really circle on that, and they're called, I'm sure most people have heard of them, the powers of attorney.
Mm-hmm.
It's the financial and the healthcare power of attorney encompassing the advanced healthcare directives. As the name implies, it simply just means that when a physician has declared that you are incapacitated, you designate an agent, you decide who will have decision-making authority over your finances and your healthcare. And that's really important when we say legally incapacitated by a physician. So, if you select your son, he can't just go to the bank and say, "Hey, my dad has the flu. Let me take everything out." No, there are safeguards in place to make sure that you are protected and so is your family. But those are really the tools that we use to protect our loved ones and ourselves, frankly.
Okay. Uh, So what are the so-called um okay. So what are the differences between revocable trust and irrevocable trust?
Excellent question. Now, this is often where if people have heard about a trust, they get
Mm-hmm.
that misconception of saying that, well, I don't need that because I don't want to lose control of my assets.
Mm-hmm.
A revocable trust with the R puts you in the driver's seat. It ensures that you maintain control of your assets no matter what. Now, you contrast that with the irrevocable trust. An irrevocable trust is a phenomenal estate planning tool that's used for specific purposes, such as protection against lawsuits, against creditors, against the government, frankly, in case someone would need something like Medicaid or something to that effect. An irrevocable trust provides you, the grantor, with immediate asset protection. However, an irrevocable trust is going to necessitate that we name a third party. So it can't be your spouse. It could be children, but it can't be your spouse if you're married to manage the assets on your behalf. So in order to get that asset protection, the government can't see that you have the ability to manipulate the asset. So an irrevocable trust inherently means you put, let's just say, your home into that irrevocable trust. It means you have to name a third party, whether it's your children, whether it's councilmen like ourselves, to manage it according to the terms of the trust. And these take a little bit more time because we work with you to ensure that if you're putting something like your home in the irrevocable trust, that your kids can't just kick you out next week. You still have say over what goes in there and the rules in place.
So, but you are no longer sort of the legal and or beneficial owner of your home.
That's correct. In order to receive that immediate asset protection, the home can no longer be in your name, and you do lose some ability to sell the home or renovate the home and such.
But for the upside of that, if you have business or you have potential other kind of exposure to lawsuits or uh, irrevocable trust will sort of, for the lack of better word, shield you from collection of that kind of judgment against you.
Absolutely. And
Okay.
frankly, most of my clients that benefit from the irrevocable trust are clients that have either rental properties that they may want to have held separately from them, or if they're in professions that are subject to high suits, such as construction and such,
Hmm.
they place those assets in the irrevocable trust for that protection. And then they
I
name a
see.
business partner to manage it, or even just councilmen again, like ourselves, to adhere to them.
I see. So why can you explain how a revocable living trust works and why it is commonly recommended for business owners and especially investors of real properties?
Of course. So the main reason why a lot of clients that are homeowners that are in this field really look for the revocable trust is because it expands with your estate. As you grow, as you buy your second property, as you buy your third property, the revocable trust will continue to house those interests because all you have to do is once the trust is established, all you have to do is that when you close on your second home, on your third home, on the deed, you put the name of your trust. And that way, the trust begins to own those additional assets. And because you own the trust, you still are able to effectively manage it. And the key interest here of a revocable trust is you always have that flexibility to convert it to an irrevocable trust when the time arises. So for some of us, that may be a first-time homeowner, and then we begin to expand to a second investment property. We can then convert the revocable into an irrevocable to meet your needs at that time.
So David, why wouldn't a limited liability company survive for this sort of purposes? Why would people have to have a revocable living trust to hold real property?
So I'll say a legal liability company is great business structure for holding real property and such. However, what ends up happening when we pass away? Most often, not absent an operating agreement, some companies have to go through the process of being wound up. And also, a lot of our assets may still have to go through the probate process. So ultimately, the revocable or the irrevocable trust is designed to encompass the rest of our assets as well. So oftentimes with the right estate plan, we work with legal liability companies. And we also work with multiple level trusts to also provide a layer of anonymity to our estates. So that way it's just a little bit harder for suits to come reach us.
I see. Okay. So what actually happens if someone passes away without an estate plan? how does probate work in New York? I suppose a lot of us are from there. And how does it work in New Jersey? How much time and expense and all that are involved for probate?
Absolutely. So I'll tailor my response a little more focused on New York and just based on our crowd. But what I will say is, so for those of us that may not be aware, probate is the process where we legally wind up a decedent's affairs, where we legally wind up a person's affairs through the court system called surrogates court. Now, unfortunately, in New York, it is a massive headache. And some of you may assume why. There's a lot of people in New York. So there is a lot of court backlog when it comes to surrogacy court. On average, we are looking at about 10 months to a year of probate backlog. So for someone that were to pass away tomorrow in New York, if they're a homeowner, if they have minimal assets, they're still looking at about 8 to 10 months to be processed. And also that
Okay.
varies depending on what county that you live in. So during all that time, no one can have access to those frozen assets. The moment the banks are notified that John Smith has passed away, accounts are frozen. And if you're paying a home, you may have to imagine, well, what happens to that home? If you want to avoid foreclosure, the beneficiaries still have to pay to keep it active, to still satisfy a mortgage. The banks don't care that John Smith passed away. The banks care that they're getting paid.
Hmm.
So during all this time of your assets being frozen, your loved ones are having to find out exactly what the bills are, when they're due, and how to make payment for them. On top of that, there are also statutory fees that come into play when it comes to probate in New York. Now, New York's a little bit different than New Jersey in that depending on the size of your estate, you're subject to different types of legal fees from the court system. And on top of that, if you are going through counsel, the bigger the estate, they are also entitled to attorney's fees based on the complexity of the work. Now, ultimately, when I talk about executorship fees, when I talk about court fees for attorneys, really we're looking at about roughly 3.5% legal fees if the estate is over a certain amount, over 500,000. And then it gets to about 2.1% over that threshold up to a million or so. And it just keeps going from there. So you're constantly having to deal with the fact that if you were to pass away in New York, you were faced with first a very big backlog. And secondly, no matter how much you love New York, they're not fixing the potholes. They're taking that money just because you're going through their court system. So that money is money that doesn't go to your family, doesn't go to your loved ones. For people that pass away either without a will or with a will, they're still subject to those probate fees and those probate deadlines.
So,
The Mhm.
sorry to interrupt. It's contrary to public, like general misperception. The existence of a will does not sort of free them from going through this procedure. Wills are not self-executing.
Yes, yes. And that is a very big misconception. Many people believe that just because I have a will, it
Hmm.
means that you're going to be able to avoid that deadline, the delays and such, or you'll be able to avoid executorship fees. It's actually the opposite. Having a will guarantees the fact that you're going to have to go to the court system, that you're going to have to pay those fees and wait all that time.
这听不见他们说话吗？
哎，请问那个高先高肖高平先生，你可以安静一下吗？你不发言，我不知道怎么把你用麦克风把你麦克风关掉。OK，sorry David，sorry for interruption，go on。
I don't
So what is executorship commission? Is this the sort of lion's share of the expense, and what's the nature of this expense?
Yes, so executorship commissions, it going to vary based on the estate. And really what an executor is, it's just a role for the person that goes to court. It's the role of the person that's tasked with winding up your affairs. So this is a person that for see a timer here, but for a person that has to go through probate, they have to provide a decedent's death certificate. If
Hmm.
they are the legal spouse or if they are the children, they have to provide a marriage or a birth certificate proving their relationship to the decedent,
Okay.
as well as providing any sort of bank records about what was left in the decedent's name, any sort of business records, any real property interests like a deed to a house.
Hmm.
And essentially, you submit that to the court, you take a number, a docket number, and you just wait to hear from them. Unfortunately, you won't hear from them for about 6 to 8 months, depending on your county. And only after that period of time is when they're going to review the file and determine, okay, you're actually missing more records because New York has its own forensic investigators to ensure that, okay, you're actually missing this account from here, or you're missing this account from here. And so it's just a very long back and forth process with a system that isn't designed to hold that volume of people.
I see.
So that's what an executor does.
Got it. Okay. So just so that everybody know, this meeting will be over in about 10 minutes. Then we can take a 5-minute break, and then we will use same link to come back to continue the conversation. So how can estate planning, David, help protect the children? Because you talk about your children, especially minors who have not reached, the age of majority, or special need beneficiaries, people who even upon reaching, majority age of majority and adulthood, would not be able to essentially look after themselves and care for themselves. How does this help with this kind of special situation?
Of course. So it helps in two ways. The first way is that with a trust, with our pour over will, we name two types of guardians, a temporary guardian and a
Hmm.
permanent guardian. Now, talking a little bit about myself, I lived in Massachusetts for a time, I lived in Connecticut for a time, and I updated my estate planning documents during each of those states because in the event something, God forbid, happens to me and my wife, a temporary guardian's role in my estate plan was to ensure that my daughter never had to spend the time with social services. They
Hmm.
never had to stay in a halfway home. There were
Hmm.
specific people that lived maybe about an hour from me that in case of an emergency, I trusted them to go to my daughter, take care of her until either my wife or I came back. Now, in a circumstance that, God forbid, my wife and I passed, a permanent guardian now is someone that I trust to take care of my daughter until she's at least 18 years of age when you're legally an adult here.
Hmm.
And I include language in there about what sort of education I would want for her, what access to tools she can have of my estate. And I also provide language for the guardians to be able to maintain my assets during that time. Now, that's for my daughter. She's young. But in the case of having what we call a supplemental or special needs beneficiary, we're talking about someone that perhaps just needs a little more assistance looking after themselves, someone that may be receiving Social Security disability, someone that may be receiving Medicaid, for instance.
Hmm.
So, in that type of case, we include language in trust that says, in the event we have this sort of special needs beneficiary, then we still want them to receive the assets. However, their share has to be held separately in the trust. It has to get held in a supplemental needs trust for their benefit, but they're not going to be able to manipulate the asset. Their asset will be held with a trustee, someone that again you designate to take care of the assets for their benefit. So that way, and when the government reviews their assets, their annual filings and such, their inheritance will not populate because it's under a separate EIN. It's managed by someone else. They are merely the beneficiary of that supplemental needs trust. So that's how having the right estate plan and having the right structure with the estate plan protects not only minor children, but the folks that find themselves in this special circumstance.
I see. So they will have a peace of mind that their child financial future is secured after they are gone, and we are managed. Got it. I see. So how should like the business interest be handling estate plan because naturally uh, in this country, as in probably we are most developed countries, right? People who have considerable amount of wealth tend to come, to have made their money, made their fortune from owning businesses.
Absolutely. So with estate plans, it's something where we sit down with our clients to really review what their assets look like, what their business interest looks like, what percentage interest they have in businesses. And we include language in the trust that gets updated with any applicable operating agreement to ensure that we have what's called succession planning.
Hmm.
That we know who's going to step up into place for a time when the principal is no longer present. And oftentimes we work with external counsel, such as yourself,
Hmm.
to be able to ensure that it also meets the business needs and we're selecting the right people and that these operating agreements are ratified. So in that circumstance, the provisions or the language we include in the trust is serves as a guide to ensure that we're taking care of every step of the way. We include membership interests, ownership interests. It's all accounted for appropriately, and that the people we want to succeed us actually come to fruition.
Okay, I see. So I suppose a lot of people in the audience or all their potential clients, they serve in whatever professional capacities, right? Maybe they're accountants, maybe they're tax advisor, maybe they're lawyer. Those people, the principal, will have assets both in the United States and abroad. So how does cross-border estate planning work? From what I remember, it's sort of another sort of even sub branch of this whole practice of law, right?
Absolutely. So it is another subsect of practice of law, and it's another special subsect of estate planning, particularly because whenever we're dealing with what we call foreign assets, meaning anything that isn't within the United States,
Mm-hmm.
we have to take great care of taxes. That we ensure that any assets that are received or come into the US are under the federal tax threshold or that are beneficiaries, people we may want to receive assets. Gets a little technical between Schedule A beneficiaries, meaning our immediate family, Schedule B beneficiaries, meaning our non-immediate family, uncles, nieces, nephews, things like that, begin to receive the assets in a tax efficient manner. So right now, I have clients in Russia, and their business generates about $1 million in revenue. So we work with counsel overseas. So that way, both states, rather both countries, they are covered in both countries for tax purposes. And we are only bringing a limited amount of foreign assets into their domestic trust under the tax limit. So that way, when they're in the United States, they still receive a benefit of what they're bringing overseas, and anything that they transport that they bring over from domestic trust to their foreign instrument is also taxed and protected according with the laws of their country. So the point being, whenever we're dealing with foreign assets, we take great care to make sure that you're not doing more harm than good. We all work incredibly hard to build what we have in this life. We want to make sure that it's protected and that you're not put in the worst position. So estate planning is very intimate, personalized to the relationship.
I see. So you need the counsel from the foreign jurisdiction sort of to coordinate, to reconcile all these differences in tax treatment, such that whether it's asset coming into the United States or leaving the United States for a foreign country would be um, sort of subject to this optimization of tax treatment. Uh, I see. So that's sort of the essence of the collaboration, or are there other sort of important aspects?
Yeah, I would say that's one of the focal elements of our collaboration.
Hmm.
The only other respect that I would say is that as I'm only a United States licensed attorney,
Hmm.
that if there are any tools that we can use from the foreign jurisdiction in the domestic jurisdiction here, That's something that we collaborate with external counsel on to make sure that